Well, let's start with what is a preference.
Thank you.
The word is undefined in Nevada law, and I've been to half a dozen seminars where people have asked judges, what the heck does this mean? Now, I know the guy who wrote that statute, and he just made it up.
If I could add something on that, because this is an issue that's kind of near and dear to me in my office, as I represent Nance in this case, and that's our appeal. And I've had another appeal of the same issue. And I think I would look at it like this. So the main distinction in McMoneagle is,
what I always tell them is this: unless your child is in danger, I always say wait at least 6 months. Because in my experience, unless the child's in danger, the court is going to say, why are you here? You were just here. What do you mean something changed? How could something have changed? How did you not know about this? We were, and so.
Well, I think that's the point. And I think you guys both did a great job of getting that across, is every case is fact specific. And it's really about articulating that to the judge, especially if you're representing yourself as the lawyers. That's our job. Exactly. Right. That's our advocacy. And that's where it comes in. All right, well, welcome everybody. My name is Andriea Aden, and I am joined by Marshal Willick, Michael Burton, and Carrie Primas. And we today are going to be talking about modifications of child custody after a final order and procedure in law and what that means. So before we get into it, first, I just kind of wanted each of us to introduce ourselves and tell the listeners a little bit about us. My name is Andriea Aden. I practice in Reno, Nevada. I'm a certified family law specialist through the state bar, and I have been running my own family law practice here in Reno for now 5 years. Marshall, why don't you tell us a little bit about yourself?
My name is Marshal Willick. I'm the principal of the Willick Law Group. We're an 80-rated family law firm in Las Vegas. I've been doing this for a very, very, very long time, about 40 years. And anybody that wants any further detail than that can probably get it off our website, which is willicklawgroup.com.
Carrie, go ahead and tell us a little bit about yourself.
Thank you. My name is Carrie Primas. I practice at the law firm of Naomi Circio here in Las Vegas. I've been practicing exclusively in the area of family law for about 12 years.
And Michael, tell us a little bit about yourself.
thank you. My name is Michael Burton, and I work as an attorney at McFarling Law Group, where I've been since 2008. And I also do personal injury at a PI firm that I run, Accident Attorneys of Southern Nevada.
Great. Well, thank you everybody for joining us today. Well, let's just jump right into it. So today, talking about how to modify child custody after a final order. So when we either have a decision by a court or the parties have entered into agreement in regards to custody, and now you want to change that, what do you do? I think the best place to start is first, what is a final order? A lot of times in custody cases, we have these interim temporary orders and people aren't really sure what that means or what to do. So Marshall, I'll start with you. Kind of tell us, what does it mean to be a final order and what isn't a final order?
Well, there isn't really much of a definition. It's a matter of fact, not a matter of law. It's really, usually it's pretty easy, however. If nothing else is pending, you have a final order. Final, unfortunately, in the world of family law doesn't mean final. It means final until something changes. So a final order is one which is not a temporary order. And how can you tell if you have a temporary order? It's because it'll have the word temporary or interim or without prejudice or some other words attached to it. But if a judge says this is the way it's going to be and there's no further proceedings pending, you're probably looking at a final order.
So what's the difference between a temporary order as far as appealability or modifiability and a final order, which is more what we're going to be talking about today? Carrie, why don't you go ahead and answer that one?
So if you have a temporary order, that is not going to be appealable. It may be modifiable in that during your proceedings, for instance, the divorce trial is several months down the road. There may be a reason to change that order if the well-being of the children is in question. If one parent decides to relocate, for instance, out of state in the middle of the proceedings, you may go back to court in the interim and change that temporary order if there's a basis to do so. But an order is not going to be appealable until it becomes final, which would be at the final custody proceeding or the final divorce proceeding.
And then sometimes we get orders that the judge will issue orally. and then it takes a bit to get that written order. What if something crazy happens between when that judge issues that oral ruling and then you finally get the written order? Michael, what do you have any options in that scenario?
Well, as far as appealability, well, first off, there's case law that basically says that an order is not an order until it's reduced to writing, and that the order can vary from what a judge said on a bench versus what is in the written order. And how that might work is a judge might go make a decision and then think about it later, and then they could issue a written order that's different later on. So you have to have a final order, and it has to be in writing. So nothing is appealable as a final order until it is in writing and then actually entered thereafter, which provides notice.
So we've talked a little bit, the word appeal has come up, and that's an alternative way, I think, than what we're going to be talking about today as far as how to modify a final order. But let's just hit on that quickly. Marshall, what does it mean if you get a final order and you want to appeal it? How is that going to be different than trying to seek a modification?
Yeah, the full range of what an appeal is all about is a little bit beyond the range of what we're dealing with today. I'll suggest that anybody wants a crash course in what an appeal is and how it works in the world of family law, they can go to the appeals page of our firm website, and there's a short explanation of the whole process and a couple of detailed articles, the most recent of which is Preparing to Sail in Uncharted Waters, Family Law Appeals. And it explains the process in detail. But the short version is that anybody that has a case is sitting in front of a judge. If you're unhappy with the final result, you get the right to appeal that judgment and ask the Nevada appellate courts to see whether or not the judge did it right or wrong. Again, they're not concerned with it's not a redo. They're interested in seeing whether the judge committed legal or factual error. So it is not for the timid, it is not to be undertaken lightly, but it is possible if you think that there's been a substantial injustice, a substantial problem, error, to go up on appeal and have the appellate courts, either the Nevada Supreme Court or our Court of Appeals, issue an order altering the result, usually by remand, telling the judge to try again.
So yes, today we're going to talk about once that order is final, there's no appeals, things have changed, and we're going to talk about what that means. So what do you do? What are your options? I have, kind of two basic options. Option one is the parties agree to change the custody order. So Carrie, if the parties just agree verbally, is that going to be enough? Do we need this in writing? Do we need a court order? How would you explain would be the best way to handle if the parties were to agree to modify a custody order?
Sure. So the best thing is always going to be to have an order from the court. Now, if two parties agree and they have a verbal agreement and they just trust each other implicitly, sure, they could go ahead and follow that, but chances are they don't trust each other implicitly in this situation. You're always going to want to reduce it to writing. And to do that, if we have an agreement, these parties can prepare what we would call a stipulation and order. Now, down here in the South, we do have a self-help center through the family court that they could simply get a form, fill out their new agreement, but it then would need to be submitted to the court, signed by the court, and filed with the court to become a court order. That's always going to be the best way to modify custody and make sure everybody knows their rights and responsibilities within that new custody order.
And same up here in the North, we have the same self-help center as well, which is a great tool for people to utilize. So now option two, parties don't agree, something's changed, you want to modify. Michael, what is that person's option? What do they have to do if they want to try to modify the custody order?
They have to go to court, and they have to file a motion to get in front of a judge in court. And how that looks is your motion is basically your, what in the legal profession we call the prima facie case. This is the facts I'm putting forth, and I know we're going to get into the legal standards and whatnot later and how the court actually looks at this, but procedurally, you put your motion together and you put everything in there that has occurred generally since the last custodial order, with some small exceptions to that, and you make your arguments to the court as far as why custody should be modified. And then the court sets a hearing. In the South, this is how this works. They set a hearing, and it's what I call a gatekeeper hearing, or we call a Rooney hearing, which is a initial hearing where the judge says, okay, if I take everything you say as true or mostly true, is there enough here to modify custody? And then if there is, the court can go ahead and set proceedings to modify custody. So the court can't modify custody without further due process than what's been established at that point. But they can deny the motion outright if they say, hey, you haven't made adequate cause, is what the Rooney standard refers to it as, where basically you don't have enough here, that even if this is all true, I give you every benefit of the doubt, there's just not enough here. They could deny you, but if they want to entertain the motion, set further proceedings where they can take some evidence and then determine then at that time if the final custody order we referred to before needs to be modified.
And we have the same local rule up here in the north where there has to be kind of that gatekeeper hearing first, and then the court decides whether or not to have an evidentiary hearing or if there's not enough there. So to modify custody, Marshal, we have kind of definitions that the Rivero case has given us, and then we have this big Romano decision that we're going to get into. So just to kind of start off, what does joint versus primary custody mean in Nevada? And in your answer, I want you to include, how do the courts define what a custodial day is?
Well, it's funny because in the history of Nevada custody law, even though we've been arguing about custody for years and years and years and years, there was never any good definition until 2009 in the Rivero 2 case. And in Rivero, the Supreme Court selected a definition for sole custody and for joint custody. And they decided that joint custody, we're talking physical custody. We'll talk about, we have to distinguish between legal and physical custody in every case. But in terms of physical custody, they define joint custody as any timeshare which is 60-40 or closer. People say, well, what does that mean? Given that we have a 7-day week, basically it means a 4-3 timeshare split. But it doesn't need to be entire days. And the judges got very creative in figuring out what constituted a day. There were all kinds of bizarre opinions from all kinds of judges, some of them coming up with 12-day weeks and other bizarre constructs. You'll find an article about that on the published works page of our website called "How Many Days Are in a Week?" and the definition from the Rivero 2 decision, where I explore all those comments. And I've done another more recent article on the interrelationship between time and child support. But to answer your question, Nevada is very different than virtually every other state. Most states have a much simpler what to count, counting for timeshare, either overnights or meals or some other combination. Nevada talks about responsibility. And well, what does that mean? And the answer is that there's some room, unfortunately, for skullduggery, but basically, who is it that's acting as a parent? Who actually is responsible for making day-to-day decisions and being responsible for the child's actions? Even if you're not in the immediate physical custody, if the child isn't in your immediate physical custody. For example, if you've got the child with the daycare center, or you've got a child in school, who is it that's responsible for the child during that time? And that's the decision the courts have to make in determining who is exercising custody at that moment. But the question for joint custody is 60-40 or not 60-40. If it's more than 60% to one parent, it's presumptively primary physical custody to that parent. If it's 60-40 or closer, all the way to 50-50, then it's considered joint custody.
So, Carrie, now with this new Romano case, doesn't matter anymore if the parties share joint or primary in that final custody order. In other words, what's now the legal standard that exists in all custody cases if you want to modify a final order?
Right. So now what has to be shown in all modifications is that there has been a substantial change in circumstances affecting the welfare of the child, and that the modification would be in the best interest of the child. And so that's if we're going to modify from one parent having primary custody and the other parents either seeking joint physical custody or primary physical custody for themselves, or if parents are sharing joint physical custody and one parent wants to modify to themselves having primary physical custody, we're going to use that standard.
And Carrie, just a quick follow-up, would the same apply if you just want to change the schedule and even keep it the same as joint or primary?
Yes.
Yeah. Yes, custody decisions, even if you're just changing the visitation.
And I would like to expand a little bit on that, as Michael was talking about sort of this gatekeeping hearing and then further proceedings, and that should apply even if we're changing the schedule. And so I want to make that distinction because a lot of times our judges are missing that and they're changing custody schedules without changing custody designations, without evidentiary proceedings, and they should not be doing that.
Well, I mean, let's quibble a little bit about that. I'm not sure we want to say that changing 2 o'clock to 3 o'clock because somebody's work schedule changed or the school is letting out earlier requires a full-blown evidentiary hearing. I think that the appellate courts are going to impose a rule of reason on this. And as long as you're not
Certainly.
substantively changing things, I don't think they're going to demand an evidentiary proceeding for every little niggling change.
No, I would certainly agree. I think I'm thinking more situations where we're going, hey, it's week on, week off, and I'd like to switch to a 3-4, where it's not a change of custody, but it's a substantial change in the schedule.
I would say often in those kind of situations where it's hopefully a minor schedule change, we do have great, like in the North, I know we have a great mediation program they can send the parties to that helps to kind of make these little tweaks to the custody agreement. So there's always that option there too, to always seek mediation. Well, let's get into kind of the nuts and bolts of this standard. You said substantial change in circumstances affecting the welfare of the child and best interest. So what does that mean? So Michael, tell us the best that you can, and let's maybe everybody chime in and give some examples. What does a substantial change in circumstance affecting the welfare of the children mean?
Well, the answer is it depends. And also on Romano, I don't think that Romano really much changed anything in a practical sense, because, and in fact, Romano doesn't expressly, I guess, overrule Truax, because they said you just misunderstood Truax. Truax actually never abandoned the premise of res judicata, which, so from a practical standpoint, when you're the movement trying to modify custody, if nothing has really changed, even though Truax kind of gave the judges green lights to set proceedings, inherently judges are not going to be keen to revise custodial situations when there hasn't been changes, regardless of what they had. That's just kind of the practical way things worked from my experience. But so then now we got one set of standards, substantial change in circumstances affecting the welfare of the child. And what the danger of this is that people started assigning dictionary definitions to substantial change in circumstances, or judges just started assigning their own artificial subjective terms to this. And they ignore a couple things. One is the case itself. So this comes from Ellis, and Ellis, in the facts of Ellis, was a brief 4-month sliding grades of the child, where a judge says, hey, in this situation, we have a father, he could be more involved, and he wants to be more involved, and we think the child would benefit. This fits. And so, and you have to look at the facts of that case, but you also have to look at Ellis in its totality. And what is Ellis really talking about other than this standard, this 2-pronged standard? And another thing they talk about is stability, and how that's a factor when you have finality and your parties have entered into a custodial arrangement, they've settled in, that there's an inherent benefit to a child in that stability. So when you're modifying custody and you're saying, I have had a substantial change in circumstances affecting the welfare of the child, what you're always up against as far as the counter to that is, on a scale here, is stability. And stability gets some weight, and how much weight it gets really depends on what's going on in the nature of what you're also trying to do. A smaller change, as Marshall alluded to before, would weigh less against stability than somebody trying to completely undo something. So one of the things that becomes appealable when you try to modify is when you go in front of a judge, how much weight is he giving to stability here? Is he giving an excessive amount of weight here to deny me further proceedings because he's focusing on stability? So what types of things do you need, or what does it actually mean? It depends on the scenario, what custody arrangements people are doing. It's a case-by-case, fact-by-fact analysis that has to be done, because like I said, it also is in relation to the request.
Well, I think the big part of the standard, that was the change, when Ellis came about, was affecting the welfare of the children. And so, Marshall, I want to come to you and get your thoughts on this. What isn't a substantial change in circumstance? I mean, I've had cases where a parent gets a new job and has a new work schedule. I know there's recently a decision on that, a specific issue, and whether or not that's enough to constitute substantial change. What other things have you seen that are not a substantial change, just to help kind of focus this in?
Well, there's an endless list of fact scenarios. And the way I usually explain it to a prospective client is that classic definition from the United States Supreme Court about the definition of obscenity, where they say, well, I really can't define it for you, but I know it when I see it. And it really is that for a substantial change in circumstance. It is relevant relative to the facts of the case. There's 100 specific examples, and some of the cases are published and some of the cases are unpublished and not citable. For instance, the one you were just alluding to, a change in work schedule may be sufficient as a change in circumstance if it affects the welfare of the child. That was the big change from the earlier standard, Murphy, to the later standard, Ellis. Previously, you only had to show a change of circumstance. Now that change of circumstance has to affect the child, not just the parents. So that was the big change when we adopted the Ellis standard. There's a case that says that simply one parent moving from a remote location to the location where the child and the custodial parent lives is not a substantial change in circumstance by itself. But, it's a matter of, to some degree, we're dealing with a matter of lawyering, because if you're a lawyer who you've got a change of events, it's not terribly difficult with a little bit of effort to properly frame how that change in circumstance affects the welfare of the child. So to some degree, you're dealing with lawyer competence. Of course, in Nevada, more than 50% of people are self-represented, and therefore they may not know what to say or what to do. For those people who are choosing self-representation, I'll just say, look, whatever change you are basing your custodial change motion on, keep focusing on the child. How does this affect the child's life, the child's school, the child's sleep, the child's meals, the child's transportation, the child's events? Tie it to the kid, not just to the parent. And you will be better off in trying to show what it is. And I'm sorry, Andrea, I'm not trying to duck the question, but I can't define substantial change in circumstance without having a fact pattern to take apart.
Well, I think that's the point. And I think you guys both did a great job of getting that across, is every case is fact specific. And it's really about articulating that to the judge, especially if you're representing yourself as the lawyers. That's our job. Exactly. Right. That's our advocacy. And that's where it comes in. And I think to add to Michael's point, I mean, stability definitely is a big part of it. And then how do you balance that with the scenario you described, Mike or Marshall, where they are moving it back, right? Let's say they were gone, and how do you balance the relationship with the parent versus the stability of the child? And I think those are the issues the judges face every day when they have these cases. So Carrie, let's talk about best interests. It's NRS 125B.0035 subsection 4 gives us 12 different factors the court has to consider. And the Nevada Supreme Court says, court, you have to consider every single factor. I want to kind of get into some of these. The first one is the wishes of the child. If the child is of sufficient age and intelligence to assert a preference. And I don't know, I'm sure you guys get this all the time. Oh, they're 13, now they can assert a preference, which I always laugh. I'm like, no. And I think a lot of these post-decree cases we see is where we're getting children into teenage years, where they're now saying, I want to live more at mom or dad's. So, tell us what kind of your thoughts on that factor, how you've seen it apply, and how it works.
Certainly. So the first thing that I always say to my clients, and I get this from doing some work with the Children's Attorneys Project, where we have children who are our clients, but I tell it to my divorce and custody clients, children get a voice, but not a choice. No matter your child's age, at no point are we going to say to them, where do you want to live? Okay, great. You get to live there. That said, again, depends on the facts, depends on the case. I've seen children as young as 5 years old interviewed in a custody case. I've seen children as old as 11 or 12 where the court says, the facts that you're giving me, mom or dad, are not enough for me to pull this child into this litigation. So it's, again, very fact specific. As children get older, obviously, the court's going to say, okay, there's a likelihood that they may have a little bit better idea of what might be in their own best interest. Or I want to hear from them because they're the ones with the real information. If a parent comes to the court and says, I want to change custody because my child doesn't like it at dad's house because XYZ, what is that because? And sometimes the child is the best provider of that information. But sometimes the other thing that we get from a child interview, which is how we're going to get that information, we're not going to get it. The judges used to just sit down and chat with these kids. We don't do that anymore. We have third parties doing these interviews. But The judge will get some information about what the child's concerns are. Why does the child not want to be at the other parent's house? And a lot of times, not all the time, but a lot of times that interviewer can sometimes opine a little bit too on, is this child being coached? Do we think this child's is saying this because they really are concerned or have issues? But the other thing that we want to look at is, again, the court's not going to change custody because a child wants to live at mom's house because mom has less rules, because mom doesn't make him go to school, these sorts of things. And so the other thing that I always tell my clients in these cases is, listen, if your child came to you and said, I don't want to go to school today, you would still make them, right? So just saying, I don't want to go to dad's house is not enough for this factor, for the court to say, okay, well, then you don't have to go to dad's house. So the court's going to take all of these things into consideration. And again, on the issue of the child interview, we have our mediation center down here does child interviews, but you also can pay a private person to do a forensic interview of a child. But the other important piece to remember is it's not automatic. A child interview is not automatic. So you can go to the court, you can request your modification of custody or just a child interview. I mean, sometimes people will go and say, a child is reporting the following things. Can we please have a child interview to determine if a modification would be appropriate? And it's going to be up to the judge at that point whether they're going to allow that child interviewed and take that into consideration for the further proceedings.
I really liked your saying the child has a voice, not a choice. That's a really good way to describe how this factor works. And I think we could do a whole nother panel on the child witness testimony law and how you get those children to testify before the court, even above and beyond an interview. So next we have, moving through kind of the factors, any nomination of guardian for the child by a parent. It's not really that common, so we'll kind of skip over that. But the next one is kind of the next three, Michael, I want you to hit, because it talks about which parent is willing to allow more frequent associations, kind of what does that mean? And then the next two, I really call those the co-parenting factors. Are the parties able to co-parent? The level of conflict between the parents, and are they able to cooperate to meet the needs of the child? What kind of things does the court look at or consider when looking at these factors?
Well, it's funny you say I'm going to take these next three together, because in my notes I have C, D, and E work together, because they do work together, and I think they do kind of bring together co-parenting. What is co-parenting, and where are the pitfalls of bad co-parenting? And they generally come from conflict, cooperation, and communication, and that's what C, D, and E deal with in the best interest factors. Whether because if there's conflict between the parties, if they're not communicating well, if their communications are one of either both, or one is very insulting, demeaning, or not existent, these create difficulties in co-parenting. And then a court's got to look at that and say, okay, is this significant enough that it warrants modifying custody? Because these things, now we're talking modifying or even an initial custody determination, looking at these factors and saying, okay, just because there's conflict doesn't mean I have to, that has to be a key in my case here, in my decision. But if it rises to a level that it is affecting parenting and to the detriment of a child, then these factors come into play. One thing I do want to say about these factors, the law does require the court go through these, but the statute and case law also makes clear these are non-exhaustive. And so many times things don't fit into these like a glove, and rather than try to force them in there, I always just argue what I call best interest or common sense factors. These are just common sense. If ABC is going on, it's a bad idea for a child to be in that environment, and we don't need to try to shoehorn it into one of these factors, because we are not limited to these factors. So I think people should know that the law requires you to go through these factors, but doesn't limit you to these factors and the things affected by them.
And one thing to point out, because we're talking about post-decree modification, and we'll get to it here in a little bit, is, well, because you mentioned how it's also considered an initial custody determination. What are we talking about now? What has to be different? So in analyzing these factors in a post-decree custody modification scenario. So we'll get into that in a little bit. But Marshall, kind of going on the line, what I want to ask you about, if you're watching this video, you can look up the statute and see the other factors. But the last two factors, and I really want to get your opinion on this, is we have the domestic violence factor and the abduction factor, as well as there's also the abuse and neglect. There's also these presumptions out there. that exists in domestic violence cases, and if there's an act of abduction where there's a presumption it's not in the best interest of the child for the bad parent, for the parent who committed domestic violence under a separate statute NRS 125C 230. How do you reconcile the best interest factors with those presumptions, and how should parties argue those?
I don't really think there's a substantial difference. I think it's just repeated in two different places. I've never seen them come into conflict. Short version is that if one parent has committed an act of domestic violence against the child's parent, or another person living with the child, there's a presumption that that person is not a good candidate for joint or primary physical custody. Now, does that mean that if there was a single incident, you're just out? And the answer is generally no. I've had an awful lot of judges over the years talk about isolated incidents, the crisis that precipitated the divorce or whatever. But there's some leeway. Some of it has to do with severity. Some of it has to do with frequency. Judges are more likely to ignore these factors on a one-off than if it was a continual pattern of behavior. And so the short version is that we don't want people who are inherently violent. The literature tends to confirm that people who are violent with their spouses or with pets or with other children are more likely to be violent with the child at issue in the case. And the same thing really applies for abduction. There's a statutory definition of abduction, but basically if you snatch and grab the kid and disappear under how it's defined, and it doesn't mean we went shopping without telling you. I mean, it means kidnap. And I don't want to get in too much into the weeds, but there is a difference. But if you've got a clear and convincing evidence that a parent has done either one of those things, then you've got a presumption against that parent as a joint or primary physical custodian. And unfortunately, sometimes we see situations where one parent was violent and the other parent cut and ran. And so the judges are trying to balance who was the good guy, who was the bad guy, and why did people do what they did. When they crafted the current version of our custodial statute, they tried to come up with language which indicated that if you were fleeing domestic violence, and I did a seminar on this, the materials are on our website. If you're fleeing domestic violence, the standard for kidnapping is much higher as a matter of proof to be held against you. The idea being that you're not required to just stand there and take it. If you have to run, and let the lawyers work out how that comes out after the fact.
So this is a good segue kind of into the next kind of area is what evidence can you use in a post-decree custody case? We're talking about an act of domestic violence. I mean, Carrie, what if the act of domestic violence happened prior to the final order or after? What does the law say on acts of domestic violence? Kind of, it has its own separate applicable law, or generally, and we can get a little bit more specific into it, when do these things had to have happened in order for the court to consider these change in circumstances that you're going to want to argue?
Right. So the general overarching rule is these things had to have happened after the final custody order. Now, and that's sort of the rule in our McMonigle case, right? You can't modify something with facts that happened prior to the order. The exception to that might be in domestic violence, where we have domestic violence that wasn't considered by the court prior to the final order. What does considered by the court mean? I don't think we really know. And I say that because I have a case up on appeal right now where we're asking that very question. Because generally, I think that we would all sort of think if you came to the court maybe with a stipulated custody agreement, and the court didn't have an evidentiary proceeding that included these acts of domestic violence that had previously occurred, our Nance versus Ferrero case says, okay, if the court hasn't considered the domestic violence, but it happened prior, you can now bring it to the court's attention. And I think the idea behind that is, right, that when you have a domestic violence situation and you have a person who has suffered domestic violence, they are very likely still under the control of that individual. And that individual may say, we have to agree to this joint physical custody arrangement. You have to do what I say, etc. And maybe once you're removed from that situation, you're able to come back and say, wait, this isn't in the best interest of my children. My children are potentially in danger. And so theoretically, Nance allows us to go back and say, there was domestic violence, the court never heard about it, the court never saw it, the court then can consider that after the final order.
If I could add something on that, because this is an issue that's kind of near and dear to me in my office, as I represent Nance in this case, and that's our appeal. And I've had another appeal of the same issue. And I think I would look at it like this. So the main distinction in McMonigle is your substantial change in circumstance. That's the basis for your modification. The reason you're coming cannot be something that occurred prior to the last custodial determination. That's the res judicata principle. But it doesn't mean that if you have substantial change in circumstances that will get you proceedings on their own, that anything prior to the last custodial order is off limits or fair game in a best interest determination. And that's what Nance was essentially clarifying, and kind of clarifying that the courts had been routinely getting McMonigle and Castle slightly wrong on this issue. In fact, I had an unpublished Nance opinion right before that. That it was in a different case, but the exact same issue. And then they published Nance, I believe, saying this keeps coming back up. And one of the other distinctions I would make about Nance v. Ferraro, and I think this is another kind of thing that happens in family law sometimes, is we get too focused on what the facts were in Nance v. Ferraro, which was DV. That was the issue in DV. But there was also a mental health evaluation that was prior to the last order in Nance v. Ferraro that we were seeking admissibility to. And my point is that just because the facts of a case say that DV that occurred prior to the last custodial order may always be relevant in a best interest determination, doesn't mean that's only limited to DV. That's not a DV only exception. And you could think of examples where that would be highly relevant. If somebody was a drug abuser and had a long history of drug abuse, and then they had a custody order and they were clean at that time, if they relapsed later, we can't act like this is the first time they ever used drugs. That would be just a complete fiction. So that's what I think Nance v. Ferraro tries to unlock, is that history is relevant if we have to take a look here. It just can't be the basis of why you're trying to modify.
Well, and Michael, you already answered my next question, which would be, is it just, DV cases, or does it also apply to other facts? I mean, looking at, I believe Nance uses like kind of the totality of circumstances analysis, that if something kept happening, or I like the drug analogy, if they were to relapse, can you not use evidence of their prior drug use? Well, of course you can. And I think that Nance helps clarify that. So when focusing and looking at your motions to modify, you're not fully limited, but definitely courts, and that's what the judge is going to do, is restrict on what they will and will not hear as far as evidence. One question I have for you, going on to Marshall, there's this preference for joint physical custody that exists in this statute. And I love when people cite it, because when I read the statutes, NRS 125C.0025 cites the preference for joint physical custody. And I read it as having actually limitation. And I want to get your opinion on that, but more so for post-decree custody issues, does that preference apply?
I don't think it goes away pretty much ever. Well, let's start with what is a preference. The word is undefined in Nevada law, and I've been to half a dozen seminars where people have asked judges, what the heck does this mean? Now, I know the guy who wrote that statute, and he just made it up. The short version was there is no definition for what a preference means. Most of the judges who have been put on the spot have said, we can't tell the difference between a preference and a presumption. So we're going to treat one like the other because we don't know what else to do with it. But it is an undefined word. I suppose, like all other undefined terms, it's going to end up in front of an appellate court at some point. They're going to give it a definition, but that hasn't happened yet. So nobody on this panel, I think, can legitimately know what the word really means. We should probably treat it as probably a presumption. Is probably the safest thing you can do with it. But it doesn't go away when you're talking about modification as opposed to original determination. It just continues to be there as something pointing the judges toward where they should go unless there's a good reason not to go there. So judges will have a predisposition to recenter on joint custody as their destination, unless you basically talk them out of it. That's probably the best way of looking at it, either in terms of an original determination or a modification, which is the subject of this seminar.
So, Marshall, I want to follow up with your statement and stick with you for a minute. So if we have an order that says the one parent has primary physical custody, you're saying that you could come back and argue this joint physical custody preference as a basis to seek a modification.
There's that old thing about the scales, and it's a scale. It may not be a 5-pound weight, but it's at least a feather that sits on the side of the scale leading toward joint custody as the judge is trying to make a decision. If the other panelists look at it differently, let me know, but I think it always acts as a drag on proceedings, as a targeting for the judge for where they're heading, unless they have a good reason to go somewhere else.
I'll follow up. I mean, I think that's definitely a little bit harder if you are modifying from primary to trying to modify from primary to joint. Whereas at the beginning of every case, we walk in and I tell my clients, listen, the preference to me is also a presumption. We're starting at joint, even though that's not, technically there's, if my client walks in and I think has a good case for primary custody, I will say to them, we still have a hill to get over because the courts start at joint. I think that hill's not as big if you have primary and are modifying to joint, but I would agree with Marshall that that's where the judges sort of always want to end up. And it depends upon what that reason for modification is. I think it depends a lot upon what the reason for primary was. If you had a stipulated agreement for primary physical custody that speaks zero to why it was primary physical custody versus a very detailed order, mom has primary physical custody because dad XYZ, whatever that is. And if dad has overcome that XYZ, even if it's his work schedule doesn't allow for a joint physical custody and now it does, if the court has any inclination that, hey, we can push it over to joint, I would agree with Marshall that they're wanting to do that.
I think it's a good place. Go ahead, Michael. Yes, please.
I just want to weigh on this presumption v preference because I have a slightly different take because it's a little bit of a pet peeve of mine. I'm surprised Marshall doesn't agree with me more. There's a major distinction, I think, between the two because in law school, we learn presumption has a very distinct legal meaning. There are legal presumptions used in other areas of law all over, the most commonly known being the presumption of innocence. And I think if we change that to the preference of innocence, that we would agree those two things are different. So I think we know what presumption legally means. And if we wanted it to mean that, we can make it mean that because we use that term all over in other areas of law. I do agree with my colleagues here that in practicality, that's the way it works. But as a fine point, this is why I was surprised Marshall didn't agree with me because he likes fine points. I disagree on the actual technicality of it.
And then just for our record, I don't disagree. I'm just saying it hasn't happened yet. One of us is probably going to be in front of the Supreme Court making that argument at some point. So I don't want this interview to come back saying, you said there's no difference. I'm just saying there's no difference yet.
Well, and when I read the statute, I'll give my 2 cents here because I find the statute very interesting. There's a preference, but there's the word if, and then it gives 2 defining requirements. If you don't have any of those 2 requirements, is there a preference? I feel like in practicality, the courts are treating it as such, but what if you have, there's not an agreement, but no, one parent's not withholding the other from the, or trying to inhibit the parent from having a relationship with the child. They just don't agree to joint.
And then I think Marshall would like this in NRS 125.003, it creates these negative inferences that could be interpreted to mean if you don't meet one of those, that you have some sort of preference reversed that way too.
Right. The statutes are not clear, and I agree that we definitely need some more clarification, but I appreciate your guys' input on how it applies in a post-decree context, because I feel like that's not always been clear, and we're so focused on the Ellis factors now in every case. Are there other arguments to bring in? And I think that the stability argument balanced with the relationship with the parent, and then bringing in these preferences as well. So kind of next, what the statute says burden of proof in it. What does that mean? And I kind of we'll start back with Marshall, but what is the burden of proof in a post-decree custody case, and who has the obligation to meet that burden?
Well, if you're looking at burdens of proof in classical legal theory, you get 2 pieces to it. One is the burden of going forward, and the second is the burden of persuasion. So the first aspect of a burden of proof is who's got to prove something. If nobody shows up, what happens? And the answer is, well, if nobody shows up, whoever's got the burden of proof loses. because they didn't show up to present anything. So somebody's got to go forward. The rested burden of proof is what happens if you're at 50-50. Does somebody have to reach preponderance? And that seems to be where the appellate courts are going for pretty much every issue where there's an undefined standard. Now, what does preponderance mean? For those who are not legal scholars out there, there is a whole range of standards of proof that you have to satisfy. At one end, as Michael was talking about with criminal law, it's beyond a reasonable doubt. We're dealing with the most serious, highest conviction standard. At the other end, we're dealing with like a traffic stop, reasonable articulable suspicion, right? Well, preponderance is somewhere in between. Think of it as 50% plus one. We're almost at a tie, but yeah, we'll give you that extra point. And if you're there, that's the burden of proof for most standards. If you're at clear and convincing for those statutes that require clear and convincing evidence, like domestic violence, then it's somewhere between preponderance and beyond a reasonable doubt. Where exactly? The courts are never going to define it in such a way that limits their discretion. So all you can do is put them in order and tell them that they're in increasing order of severity. But no lawyer could or really should try to exactly define these terms, because it's going to be highly individual with the individual case. If my colleagues here feel differently, feel free to chime in with your own definition. But I'm unable to I have had clients, give it to me in math. Are we doing 41%, 47%? And I can't do that. I'm sorry. I can't, because the courts won't. If they would, then I would be happy to repeat it to you. But you're asking me to just make stuff up, and I don't like doing that.
Well, and I think in the context of a custody case, the burden of proof exists. It's in the law that the moving party, bears the burden to prove their case, both prima facie in the initial motion and then preponderance at the hearing, unless it requires clear and convincing on those special factors. But at the end of the day, we're talking about children, and we're talking about human beings, and the courts are going to consider the facts and make its decision based upon really what's in the best interest of the children at the end of the day. But I think it's important just to include, to know, hey, if you're going to bring this motion, you have to have something. You can't just bring it because you feel like you want it to change. And that's kind of where I was wanting to go with that.
Can I expand on that just a little bit too? I wanted to circle back. I agree a lot with Marshall's, I'll know it when I'll see it example. And I think that's really important for people to understand. And what you just said too, Andriea, that you can't just go into court and say, I want to change it because I want to change it. You have to have a reason. But I think it's important for people to know that we don't have a list of what will get you a change in custody. We don't have a list of what meets that burden. And so to the extent possible, and I know that, again, 50% of our litigants are unrepresented. To the extent possible, though, that if those litigants, who obviously we're trying to reach today, can have a consultation with a lawyer, can go to ask the lawyer program, something like that, because it's hard for us to give a complete picture today. It's impossible for us to give a complete picture of what to do and when to do it, because we don't even know, because it's not laid out very clear.
Well, and Carrie, that's a great segue into my next question, which is timing. When's a good time? When's a good time to file the motion? 1 month after the final order? I always tell my clients, you may at least wait till the ink is dry,
right?
Unless it's something substantial. But kind of give your thoughts on timing wise.
So, obviously, if somebody comes back 2 years after the final order, right, and the new facts, the change is something that in any event would be significant and sufficient for a change, 2 years is certainly enough, right? When people come to me immediately after the final order, a few weeks, a month, what I always tell them is this: unless your child is in danger, I always say wait at least 6 months. Because in my experience, unless the child's in danger, the court is going to say, why are you here? You were just here. What do you mean something changed? How could something have changed? How did you not know about this? We were, and so if it's something like, for instance, the grades are slipping, the other parent's not getting the child to school on time. The other parent missed a volleyball game, a therapist appointment, a well check, these sorts of things. First of all, there's a lot of adjusting that's going to happen. After these final orders, you're going to have parents learning to co-parent. You're going to have parents learning to parent. You're going to have parents who've never parented their children any significant period of time, because there was a relationship where you had a primary caregiver and the other parent didn't have a lot of involvement. And so there's a lot of adjustment that occurs. And in that adjustment period, things will happen with these children, unfortunately, like being late for school, not having homework done, missing events, falling down and scraping their knees more than they ever did before. And so I always tell people, wait at least 6 months. If it's these sorts of small things that are probably attributable to that adjustment period, again, unless your child's in danger.
I just worry a little bit, Carrie, that the people listening to this are going to say, "Oh, I got a 6-month magic window." Be very careful with any specific time period. There's this quote that will be thrown in a litigant's face, and we've all seen it multiple times. We're not going to allow a litigant to file immediate, repetitive serial motions until the right circumstances or the right judge allows them to achieve a different result based on essentially the same facts. So we're back to what constitutes a change of circumstance, what constitutes a material change. And again, the only thing I would suggest to people before you pull the trigger, at least consult with a family law specialist, because again, it may just be a matter of know it when you see it, but when you've seen 10,000 of them, you're a little bit better about discerning what a judge is likely to believe is and isn't significant.
Can I weigh in on that one also?
Yes, please, Michael.
Okay, I would agree. I understand what Carrie is saying, but the time frame things jumped out at me too, because I worry about this, have the same concerns. So this is what I always tell my clients. To modify custody, it's going to come about in 2 ways. It's going to become either through a series of things that accumulate over time, or one large event. One large event, or maybe 1 or 2 medium-sized events. Those events, you're going to know when you see them, which we've said a few times now. They've been arrested, they're in jail, they're in rehab, they've fled, they're indicted, whatever, right? Those ones we're going to know right away. We can move on these right now. We don't need to do any more fact finding here. We're ready to go. The other ones require, my advice to those clients are document, document, document. If there's deviations in timeshare going on, another party not exercising their time, which is one of the major components that people seek timeshare or custody modifications for. My advice to people to do that is to document, and again, not to give a time frame, but I usually say like a year time period to show some sort of historical time frame of custody, but it's something that you don't want to do too soon. And here's the thing we haven't talked about today is why you don't want to file a motion too soon. And the reason is credibility. If you start filing motions too soon and you don't meet that threshold that's set at that gatekeeper hearing and you start getting denied, that's going to become a pattern. And every time you seek modification thereafter, your chances dwindle and dwindle and dwindle. And you start to get looked at, as Marshall said, as a serial litigator trying to file the same thing, repetitive motions to get a different result. So that's kind of my viewpoint on what I advise my clients to do and the types of things to look for and the timeframes.
That's all great advice and great examples. And again, I think articulates the difficulties of our jobs when people come to consult with us and analyzing a case. When is the right time? What evidence do you need? I say document, document, document all the time as well. And sometimes what if you've waited too long and if you acquiesce to the behavior and if you allowed it to continue, is the judge going to hold that against you? I've seen that happen as well. So there's, it's definitely a tough area to navigate. And that's, why we're here to help and why we're here to do this. I want to segue into kind of a separate area because I think the Romano case, kind of our last few minutes here, and talk about that a little bit, is, and Marshall, I'm going to start with you. So we kind of made our circle again, is what if you have an agreement and the parties say, hey, we share joint, but really they don't? Under Romano now, can you go back and seek to modify to conform the agreement to the law on how the law defines custody?
I had a lawyer write in. I think it might do our audience some good to tell them basically what happened in Romano.
Yes.
We had a contested divorce case, and they had, I think, 7 or 6 or 7 or 8 kids. They had this horribly complex custody arrangement, which they defined as joint legal and physical custody. But in reality, some of the kids were mainly with dad, and some of the kids were mainly with mom. And that was the reality on the ground when they made their agreement. And what the district court judge did, 8 months after the divorce, dad walked in and said, I want you to recognize a de facto change in custody, because these kids actually live with me. Those kids actually live with her. And I want the court to recognize what the existing arrangement is. And the district court said, no, this was the reality when you made the deal that you made. So the lesson for Romano really is be careful what you agree to, and don't agree to things that are not true, and then ask the court to change the order based on what was actually true at the time that you made the agreement. Now, a lawyer wrote into me and asked, does this mean that the de facto custody case law is gone? And my answer was no. It just means that it has to have occurred since the time of the last custodial order. So if the last custodial order was that the parties had joint, and after that, things changed on the ground, the doctrine is still alive, and you can still ask the court to recognize a de facto change in custody. But if that was true when you made your agreement, you may be boxing yourself in a way that you don't want to. And the judge could refuse to recognize the reality of the situation. You could be held to the fantasy that doesn't reflect the matter on the ground. I may have gone so far around the bend that I didn't answer the question you asked. I'm not sure. Frankly, I forget.
No, that's okay. And I can go to Carrie next. How do we advise, or what would we advise clients or people watching this, if, how to be cautious with what you're putting into a stipulated agreement? And let's say a lot of times we strike deals. Let's call it joint when really it's 60%. What is the risk of doing that now under Romano? Can you file a motion to conform after the fact?
No, I mean, if you agree to that, you're stuck with that. And and frankly, I mean, I advise my clients that way before, telling them, sure, certainly you could maybe come in if there's a change, and if there's another change of circumstances, you could also cite, and the timeshare isn't 60-40, and so we should change it. But I've sort of always advised my client, you're stuck with what you agree to until there's a change in circumstances. I think the court, honestly, in Romano, has sort of just said, we're going to keep doing what we were always doing. The case law didn't say it before, but I think the judges were, starting to lean this way anyway. You agreed to this, and the courts are reticent to change that without a reason to change that. Again, back to that res judicata principle.
So then, Michael, how does that affect child support? I mean, that's kind of the logical conclusion. That's why people would be wanting to conform, right? The schedule, they're not wanting to change the schedule. It's a monetary issue, right?
I was going to bring this up, but I thought this would be too far astray. So it's interesting you did. This all is about child support. And I think one of the biggest flaws that in the family law community that we didn't get done was when we changed the child support laws, that they weren't able to incorporate in some sliding scale type things. And I know there's a number of reasons they weren't able to do that, from systems issues with the district attorney's office to other reasons. But these distinctions really come down to child support, and we have very draconian results between these titles and what can happen as far as the results of a child support calculation. So we have senseless fighting over what can amount to very small amounts of time with the child for a week that could be eliminated and ease the burden on the judicial system to actually hear genuine parental disputes if we could just come up with and implement a child support system that gave some sort of credit along a sliding scale, so that it's not such a punitive thing if somebody says, hey, look, I think it is in the best interest for a child to be like in a 2-5 situation here, but I don't want to do that because it's going to be, I mean, sometimes these swings are drastic one way from another, to not paying to paying a ton. And then we have you pay kind of the same amount if you're on this threshold as whether you have really no custodial time at all. And we have these statutory adjustments, but that doesn't really cut it because they're inconsistent and you can't rely on them, and they don't account for every situation. Really, they don't barely account for the situation I'm talking about right now. So I think that was a big mistake to no matter what the consequence, to say we couldn't afford to do it at the time or to redo these systems. We're just shifting the cost burden to the family court system, having to create new departments to handle all these disputes. It seems like it would have been something we should have figured out a couple of years ago.
Well, if I can just jump in on that, that's
Yes.
one of these, there is no perfect answer. There's an article on our child support page about the relevance of time schedules to child support obligations. And we talk about cliff effects. And that's basically where Michael's talking about there, where if you step over this one little change, there's a massive change in child support. but there's no free lunch.
Marshall, I just want to point out one thing, and also that can be subjective from an interpretation of how you count time, where we talked about earlier, from judge to judge. So the same custodial agreement can be called two different things in two different departments and have drastically different financial consequences.
And that's in that article as well. It's opportunities for some skullduggery. I will say that we have a child support commission, and it currently is meeting, and they're talking about refining our regulations. I was sent in as the Academy, the American Academy of Matrimonial Lawyers observer and representative. And we are probably going to be seeing some changes to Nevada's child support regulations coming out in about probably, it's always difficult to predict bodies, but 3 months to a year. And hopefully some of the stuff we're talking about today will get, refined, defined, improved.
Well, I think it's some what we learned from Romano and all these issues is be careful what you agree to. You're going to be held to it, and you're not going to be changing custody or child support unless you can meet the legal standard to do so. And so we're here today to help and educate everyone on what those are and what that means. So I just want to say thank you, everyone. I want to give everyone one last opportunity in our last couple of minutes for any kind of final thoughts. Go ahead, Marshall.
Really none. It's just it's difficult. It's complex. There's a lot of information, and be careful. So do your research, do your reading. As I said, there's stuff available online where you can try to get educated. But before you march off to family court, you should certainly consider consulting with a family law specialist, somebody that knows all this stuff and deals with it all the time, because often we can prevent people from making very expensive mistakes if given an opportunity to do so. And again, you'll get an opinion. If you're not happy with the opinion you get, consider asking somebody else, but do try to understand what you've got. And anybody that wants to start their education on it, we've posted a great deal of this stuff on our firm website. So I'll refer you again to willicklawgroup.com, which has articles on most of the subjects we've been talking about here today, and might provide a basics for education.
All right. Thank you so much, Marshall. Carrie.
The only last thing I want to say, in addition to what Marshall said about, educate yourself, seek legal counsel if you can. Again, we have the Ask a Lawyer program. The only final thing I want to say is everybody's experience is different. Every case is fact specific. And like Marshall said, judges differ on little things. So I would caution pro litigants from, assuming something will go a certain way in their case because they heard somebody else's story or because of somebody else's case, because every case is specific. So you do want to do your own research and seek legal counsel if you can to your specific case.
Yes. Thank you so much, Carrie and Michael.
I'll reiterate what my colleagues said, to get that legal advice, but mainly so you don't jump too soon or do something that hurts your credibility later on. And that legal advice you're getting is going to be objective legal advice about your situation, because as Carrie just said, the things that matter to you, they may not matter to the court. These judges have on average 600 or more cases down here in the South, and they see a lot of really horrific stuff. So what you think is so dramatic in your life might not be to the court. So you want to get that run by an objective attorney. And the most important thing, I think, is any attorney who tells you changing custody is easy or fast, just run. That is not the case. These are standards. There's due process rights involved, constitutional protections in place. And so there's nothing fast or easy about changing custody.
I think we could spend at least 2 more hours, if not more, on this topic. There's a lot more to talk about. So yes, I agree. Everybody, seek advice of an attorney and do your research. And just thank you, everybody, for being a part of this panel today. And we hope everybody found it helpful.
Great. Thanks, Andriea.
Thank you.